Hi, my name is Tony Sgro. Welcome to Vegas Law Podcast. I'm here with my co-host, Darrell Craig Harris.
How you doing today, Tony?
All is good. All is good. Little chaotic, little busy, so it's where I thrive.
Yeah, well, it's good. It's a business, so it's good to be busy.
That's right.
Awesome. So one of the things we were talking about recently was what happens when somebody gets arrested? Like, what should they do? What should they not do? Let's talk about that.
Sure. So many people have the misfortune of being arrested from all sorts of different, or for all sorts of different crimes, from misdemeanors all the way to, warrants for unpaid traffic tickets, although those days are coming to a close now, all the way to serious felonies. And there's always this dynamic of, what to do when you get arrested. And the long story short is, as much as we respect police officers, as much as we are appreciative of what they do, they are out there in our community doing a job. And when they do come in contact with private citizens, and those private citizens are going to get arrested, and the allegation is, some kind of crime that's going to develop itself through the system, it is hard to put on ice the things that we grow up with in terms of police officers being persons that will help us, et cetera, and understand what your rights are. And, therein lies the dynamic that needs to be approached. So on the one hand, you're going to get arrested. In that particular circumstance, the police officer is not your friend. The police officer is looking to do their job, which includes the procurement or garnering of evidence such that they're going to be able to convict you of a crime. What is the most difficult thing for a defense attorney like myself to overcome is when one of my clients decides that it's in his or her best interest to confess to the thing that they're being accused of. And I understand the desire to want to do that, to cleanse one's soul. And I understand if the client wants to go down the road of, hey, I did it, I was caught, I just want to see what I can do down the road, try and cut the best deal possible, etc. I get all that. The difficulty comes with the client that comes to me and says, the case outside of what I just admitted to is relatively weak. However, I did admit to it. What can you do for me? Well, it's hard because juries believe the words that come out of an accused's mouth more than anything else. And so are there circumstances when someone feels forced, compelled, et cetera, to make a statement to the police? Sure. But those sorts of statements typically are the ones that resonate the strongest with any trier of fact, a judge, a jury, et cetera. And man, it's hard to unwind what you just told a police officer. So what should you do when you're arrested? Understand you're in for a little bit of a process. You're going to go down to the jail. You're going to get booked. You will be told what, if any, bail you're going to receive. You'll have the opportunity to post bail. You might get released on what's called an OR, or an own recognizance release. And then from that period of time, right, when you get released, you need to go hire yourself an attorney. And when you engage with that lawyer will explain to you what the process is about. You're going to go through, for a misdemeanor, you're going to go right to trial. For a felony, you're going to have a right to a preliminary hearing. You may want to have a speedy preliminary hearing for tactical reasons. You may not want a preliminary hearing within 15 days for tactical reasons, and so it goes. So one of the things to do if you are arrested, 100% cooperate with law enforcement. Do what they ask you to do. If that means step out of the car, put your hands behind your back, do those things. What you need to understand, though, is cooperation with law enforcement does not include and then also tell them exactly what your position is, right? And so cooperate.
Right. That comes back to the right to remain silent, which we always hear, but that's where that comes into play, right?
That's right. You do have the right to remain silent. You do it in the area of DUI. You do need to comply with, walk and turn test and the field sobriety test. You do have to comply with the breath or a blood test because your driver's license is considered a privilege and not a right. So you do have to comply with certain things because they impact your ability to drive and be on the road. Short of that, though, you don't have to make any statements. In other words, even the nuance of how many beers have you had tonight, you don't have to answer. But if the officer says, okay, well, get out of the car so I can do the walk and turn test, or I can have you, lean your head back and close your eyes and try to touch your nose, yes, you have to do those things. So the first thing you need to do is be polite and respectful. Understand that police officer is just doing his or her job, period, end of story. They didn't seek out that night to go find you to arrest you. So try to understand as best as you can to not take it personal, that they're just doing their job. Second thing, don't engage in conversation with the officer because it's not going to help you. In that one very particular circumstance, they're not seeking to help you. They're not your friend. They're looking to get evidence that they can use against you to assist in their efforts to convict you of whatever crime you're being arrested for. The next thing is to understand when you're going to go to the jail to be processed, whether you get an own recognizance release, whether you post bail, whatever the situation is, you're going to go to the jail. During the time that you're at the jail, in between that time and the time you get out, you will likely get on the phone. You're going to call a spouse, a parent, a child, hey, I got arrested, I need you to come pick me up, or whatever it is. The natural inclination of the person receiving that call is, what happened? Then the natural instinct is to say, what happened? So the second big piece of advice is to realize all those phone calls are recorded. And so, and in fact, they have signs above the phones that say these calls are being recorded. You'd be shocked how many times the persons who get arrested then decide to get on the phone with a big sign that says these are recorded, and they make admissions during those telephone calls, which are later used against them. So, in other words, someone gets arrested, they tell the police, I'd rather not speak with you, I want an attorney, fine. Then they get processed, they get put into a holding cell until they get out. They're invited to use the phone if they want. They call someone and they say, yeah, man, I just got picked up on a whatever kind of charge, and then they make a statement that incriminates them. Well, that comes into evidence just as much as a statement to the police.
Yeah, and I think a lot of people, well, the phone call thing is interesting because I didn't know that, but at least they give them the sign. So if you're willing to do that, that's obviously not a very smart thing. But I think, do you think with the situation with the police officer, when you get pulled over, we're always taught like we want to be liked and we want to be trusted. Do you think that those instincts instantly kick in? Obviously, too, people are also they're upset. That probably plays a role into all that, I would guess. But
no doubt about it. I mean, police officers and members of the general public are meeting each other for the first time in the worst possible circumstance. The person that gets pulled over or confronted by the police is nervous, afraid, scared, and they can't help but believe that if they just are cooperative in that moment in time, that somehow they'll talk themselves out of the situation. Right. And the police are there and they're speaking to someone they don't know who they think has just committed a crime. So they're leery and suspicious as well. And so that's why I can't stress it enough. The most cordial, professional, amicable scenario that exists is the one that you should choose. Save and except for, don't speak to the police unless you have an attorney there first. And you know what? There are the times where we do let our client speak to the police, but an attorney can sift through what's the officer looking at, what specific things are they looking for, do they have the right person, they can also help discern between, do you want to speak to my client because he or she is a witness or because they're a target, right? Those are big differences. And persons that don't have legal knowledge, skill, and experience don't always understand the nuances there. And then there's this term of art we use in law called a subject. Well, when the police say you're the subject of an investigation? Well, that term is clear as mud. Being a subject of an investigation means we don't know who or what category you're going to fall into.
Right, they're kind of fishing in a way.
They're fishing, and they're going to say you're either going to be a witness or you're going to be a target, depending on what you tell us. Well, that causes someone to say, well, then I'll just give information so that they conclude I'm just
trying
a witness.
to talk their way out of a situation.
Right,
Exactly,
but here's the other thing. Police officers are allowed to lie to you when they're doing an investigation. And so you don't know what's going to come of that. And so police officers can tell you things like, hey, we found your fingerprints on the gun, or we found your DNA at the scene, or whatever it is. Those things do not have to be true. The law in Nevada is such that police officers are given tools in order to conduct an investigation and to interrogate potential witnesses and to interrogate potential defendants. And they're allowed to say things like that, and that's okay. All of which bakes into, this is why you don't want to speak to the police without an attorney advising you first. Could the attorney say, you know what, based on everything I know, it's going to be okay to speak to the police? That could happen. Is that a rare exception to the overarching notion that our clients don't speak to the police? Yeah, that's the rule. But there are exceptions.
Yeah, and I mean, and ultimately, too, even a guilty person is entitled to a defense, so you want to set them up for the best possible outcome and avoid a lot of problems. Like, I mean, that's part of the reason why we're doing the podcast, is to give people good information. Like, a lot of people would not realize that the police are allowed to lie to you during that investigation, which it seems like that shouldn't happen. But of course it does happen. And we know some cases personally that we've dealt with where
For sure.
that happened.
And you say, guilty people, listen to me, unless the state can prove it, unless the government can prove it, it didn't happen. So to me, it's an examination of what the evidence that's been put together it suggests. And in the case of someone who speaks with the police, that quantum of evidence is pretty compelling. Alternatively, if I get a case and no one said anything to the police, in terms of the accused hasn't spoken to the police, now I have a completely different outlook on what that quantum of evidence looks like and feels like. The only time a person is guilty of anything is if the state has put together enough evidence to prove someone's guilt beyond a reasonable doubt, right? And unless and until that happens, there is
Presumption of innocence.
Presumption of innocence, which obviously, doing what I do for this long, I can't underscore how much I value that and how much I believe in it. And, we do these things all the time. So I'm in front of juries often. I have been in front of juries often in criminal cases. I stopped counting at 125 jury trials. When we're talking about, which is a lot, by the way, when we're talking about a criminal case, people hear on television the presumption of innocence, right? But there's always this little bit of disconnectivity. I know what I think presumption of innocence is, because if it were ever to apply to me, this is what I think. But that person sitting over there at defense counsel table, I mean, there had to be something, right? And so I have to
overcome that.
I have to overcome that. And so
yeah.
I ask questions like, do you believe in the old saying, where there's smoke, there's fire, right? And I get people to start talking to me about that. Is it possible for the police to arrest someone who has committed no crime? Is it possible for the police to arrest someone and then later that person's entitled to a verdict of not guilty? And so we talk about those concepts with jurors way before they get selected. And so when it comes to presumption of innocence, I always ask them, tell me what that means to you. And more often than not, they have an idea of what that means based on a TV show, a movie they saw, whatever it is, or maybe they have friends who are lawyers who have explained it to them. But the way I've always looked at it is this. I need you to think of the one person in the world that you just know would never commit a crime. Your son, your daughter, your parent, your mom or dad, your sibling, whatever it is. But everyone typically has that one person that they think is as honest as the day is long, and they're just not going to commit a crime.
Right. Yep.
Now, what I want you to do is to pretend that that person got charged with a crime. What would it take for you to have your belief system turned around so that you could consider that that one person you've held on to in terms of the bastion of truth and honesty, what would it take to convince you, you know what, maybe your belief in that person was wrong? That's what my client, the stranger you don't know, that's what they're entitled to. And when I explain it that way, it is remarkable to me how much, you could see people literally lean back.
It really flips their perspective.
It really does, because it is easy to have one version of presumption of innocence for someone that you really don't know, because they're really not giving that person.
Or maybe they look a certain way, they have a certain skin color.
For sure.
Whatever. Yeah.
For sure. And when someone is faced with, well, okay, if my mom was on trial, what I want to make sure is this, this, and this. Okay, great. Let's talk about your mom then. And the reason you feel that way is because of your life experience. Well, I'm telling you right now, the only way you can sit and serve as a juror in this case is if you have the mental wherewithal to impute that level of presumption of innocence to someone you've never met before. Can you do that? And that's when we really start to develop the notion that we have a juror who could actually get there mentally.
Be fair and impartial, like as they should be. But it's so hard to get rid of those biases that we've all grown up with. And you mentioned even things like television, like social media. Overcoming that has got to be a huge challenge for you.
It is. And we talk to the jurors all the time, and I speak to them about their role is as a fact finder. The judge does the law, the jury does the facts. And it is hard for me to explain sometimes that the potential juror is not the detective in the case. So I say, do you realize you're not the detective in the case? And then they say, what do you mean? And I say, well, your job is not to solve the puzzle. It's not to solve the mystery. Your job is much more focused. Your job is to understand that person X is charged with this kind of a crime. Your only job task is there enough proof such that it qualifies as beyond a reasonable doubt that this person in front of you is responsible for the commission of that crime? You don't get to say, well, if not them, who? You don't get to determine whether or not some other person did it. You only have the obligation to understand that this is the person they've charged. This is the person that they're going to present evidence for. And in the absence of beyond a reasonable doubt, you have an affirmative obligation. And I tell them all the time, the DA wants this. The state of Nevada wants this. They want to know if they haven't met their burden that you're going to assure them you're going to vote not guilty. So it's just a constant changing of perspectives that is really tough for us to do. And I also go through it, you understand this isn't like, Criminal Minds, NCIS,
Right.
Law and Order, whatever it is, whatever your favorite of those shows is, where, the pattern is, okay, accused subject A, oops, it's not subject A, but now we have subject B. You have the compilation of evidence as to subject B. You have the jury trial. You have a little bit of a fight. And then in the end, the jury figures it out and the guy's guilty.
Right.
Okay, that's not real life.
Yeah.
And it's hard because so many people write down on their jury questionnaires in cases where we get them, what TV shows do you watch? Obviously, as a testament to, whatever, 20 seasons or whatever of, Law and Order.
Right, they're super popular.
They're super popular. It's hard to overcome that. And then there's this other show, Forensic Files. Well, Forensic Files features the story of why people are guilty, right? I don't know that there are any shows that go through evidence only to conclude that the person was wrongfully accused, right?
Right,
You can
exactly.
probably balance those shows on the head of a pin. Forensic Files is particularly troubling because they use as pillars of evidence, they use science all the time, right? Forensic Files. But they use science that has been stricken as invalid science in the last 10 years. So when we had President Obama, he commissioned a group of scientists to travel around the country, and they came up with a report after the preeminent experts in different forensic fields put their heads together to really test the viability of certain sciences. And so he came up with what's called the PCAST report, the President's Commission on Applied Sciences and Technologies. What did we learn in the PCAST report? Well, they used to compare carpet samples, fiber samples. The commission appointed by the president unanimously determined that carpet fiber sample evidence was junk, and they got rid of it. Just like that overnight. They flipped a switch, you can't use that anymore. Well, I watch Forensic Files occasionally, not necessarily because I like the show, but I want to know what they're putting out there in the world.
Right, what potential jurors might be seeing.
Right, that I have to deal with. And I'll be damned if they don't show carpet fiber evidence all the time.
Right.
The other one that's junk science now is hair analysis, hair comparison. You can't do that. Well, if you watch Forensic Files, and if you watch enough of those shows, you're going to see a lot of hair evidence that was used to convict. So we have real-life examples of television shows that show examples of junk science used to convict
Yeah,
certain
and it
people.
gets out into the public sphere, and then it's really hard to pull that back, right?
Correct. And so, the PCAST report was a pivotal moment for those folks that do what I do, because it eliminated a lot of those junk sciences, which are no longer permitted to be used in a courtroom. Now, I know that because this is what I do. The average juror that just watched Forensic Files and saw an episode about how someone was guilty because of carpet fibers that matched, they don't know that. And so they assume everything coming from the scientist at the crime lab is going to be 100% accurate.
Right, and they hear the term scientist just like police officer, and there's a certain credibility that comes with that title, and you have to overcome that as an attorney. And is that one of your big challenges often in court? Well, actually, even just picking juries.
Yeah, it all starts to me with picking a jury. If you're trying to figure out what the jurors' perceptions and expectations might be, and you're at closing argument, you've already lost the case. It takes a long time to pick a jury, and it should, because we really need to understand what people think. So another question I ask in a criminal case is it possible for a police officer to come in, full uniform, got the badge on, the gun on, swear to tell the truth, and then lie?
Right.
Is that possible?
Happens. I won't say all the time, but it has happened often.
Right. Well, I think it's happened as well, and not all police officers are bad. There are many, many good ones, and the good ones outweigh the bad ones. But can it happen? And you would be surprised how many jurors say, well, I suppose anything's possible, but if a police officer takes a stand, and I use this, inane example, the police officer says the light is red, layperson says the light is green, do you automatically believe the police officer? And
course.
People say, yeah,
Yep.
because they have special training, knowledge, skill, and experience.
And we've all been taught.
And they've all been taught that way, and so the layperson loses, right? It's like the old adage, why does every prostitute have to have a bad eyesight, right? They can never be an eyewitness in a case because of what they do for work. So, yeah, the perceptions are real. The perceptions are very strong. But you can see just in this little exercise here, it takes a long time to get to the underbelly of what we're dealing with in terms of who is our prospective juror going to be. And then if, what's the allegation? Is it a hate crime? Is it a crime against a child? Is it gang related? Is it a drug deal? And then, if you have a drug deal, just for example, could you have a juror sit on your panel that had a family member die of a drug overdose? Probably not, right? Because they have strong opinions. So we try to
And they might potentially try to sway other jurors. That's another part. That's a whole other topic in a way too.
For sure. I had a homicide case years ago, and obviously we say, has anyone in your family been the victim? Well, have you or anyone in your family been the victim of any crime? And when it's a homicide case, do you know anyone who's been the victim of a homicide? Those are about as basic as it gets. And so we had a gentleman on one of our jurors who said, no, never been a victim. No one he knew had ever been a victim. And we do a very lengthy murder trial. I think it was a month and a half. It was a capital case. They convicted, but they gave our client life with parole. Okay, case is over. And then we learn that the main voice in the back room during deliberations was an older gentleman whose sister was murdered. And he never revealed that to anyone. So now here we go. We have to have everyone come back. We have to have the gentleman explain why he didn't say anything. All of that caused the last many, many months for both the DA side and our side.
So in that situation, would you request a mistrial? I guess you have to kind of go into the discovery phase again and figure out what's going on.
And in the end, we asked for a mistrial, and that particular case ended up getting negotiated because no one wanted to
start
again. Right. But, in something as serious as being a juror in a homicide case, I have had personal experience of people that have not told me the truth. And they had to learn in that one particular circumstance of what happened afterwards. And it caused everything to be thrown off balance.
So if in that situation, if they don't disclose that, are they potentially liable for criminal prosecution?
Theoretically.
But nobody wants to deal with it.
Yeah, I mean, the last thing we want to do is ever give persons an additional incentivization to not want to be on a jury. Right. It's already hard to get people.
True. Especially for homicide, that's going to be a long trial, probably.
Correct. And people aren't, usually waving their hands to get first in line to take 6 weeks out of their life and decide the fate of someone in a murder trial.
Yeah, and if they are, you'd have to be suspicious of why. Exactly.
Exactly. So it takes a lot. So that's why it takes so long to pick them in the first place. And that's why, all we can do is ask for unfettered honesty. I would say most of the time we get it. Sometimes, though, we don't. So, when you have a personal experience like that, it just causes you to press a little bit more the next time you're selecting a jury. And so your questioning of the jurors, your experience and level of engagement with them is a continual evolution based on what just happened to you in the last case.
Explain, you mentioned capital murder, so explain the difference between that and I don't know if you would say a regular murder case, but explain what the differences are.
So in Nevada, we have what are called aggravating circumstances. And there are a list of aggravating circumstances that exist which elevate an otherwise non-capital murder case, and they elevate it to creating the risk of the imposition of the death penalty to someone accused of a homicide. So, for example, if someone's been convicted of a prior homicide or they have prior felonies, those are all what are called aggravating circumstances. So if someone has prior felonies and then after they get released from those felonies from prison, if they went to prison, they can be exposed to the risk of the imposition of capital punishment. If the person accused of murder does not meet any of the aggravating circumstances, then they're just charged with murder, which means they can get life imprisonment without parole, they can get life imprisonment with parole, or they can get a definite term of 20 to 50 years. If aggravating circumstances exist, the fourth penalty option available is the death penalty.
So does Nevada, and I actually don't know this, does Nevada currently have the death penalty, and have they executed anybody in the last, say, 10 years?
So they do very much have the death penalty. We're typically in the top 3 or the top 5 in the country that impose the death penalty. And it's an interesting thing. So there are countries in Europe that have drugs that they develop which make up part of the recipe for the cocktail to be administered for the imposition of capital punishment. So to make it humane so it doesn't violate the Eighth Amendment, there's a sedative cocktail, there's one that paralyzes the nervous system, and then there's the drug that is going to ultimately cause you to die. And when manufacturers in Europe learned that their drug was being purchased in the United States to be part of the cocktail for the imposition of the death penalty, they stopped selling it to the United States, to the prison system. That caused some problems because those drugs were out, they get past their expiration date, and they can't use them anymore. The other thing that we had happen in Nevada was the death chamber itself had some infirmities in it that were never repaired. So between the absence of the drugs to administer the lethal cocktail, as well as the infirmities in the death chamber, as it's called, Nevada hasn't affirmatively executed anyone in a long time, save and except for what they call the volunteer. The volunteer is the person that says, I don't want any more appeals, I'm tired of this, just please execute me. And there is a process through which, if you are on death row, you can waive everything that you want to waive. And there have been a couple volunteers in the last 15 years or so.
And do they give them, I guess they would give them options. What are those options now?
Well, they
currently?
give them the administration of the lethal cocktail, but they waive, that person has waived any defects
Oh, okay.
relative to the cocktail, whether or not it's cruel and unusual punishment, and all the sorts of things that come
They're
with.
just ready to be done. Yeah.
Correct.
What's your, and I mean, your record is pretty amazing for, and I wouldn't say acquittals. What would be the term? Basically keeping people off death row.
Yes. So I have had, well, I've been doing this for 35 years or so, and I have had hundreds of murder cases. Of the hundreds of murder cases that I've had, a good deal of them have been capital cases. Sometimes capital cases can get negotiated, but sometimes they don't. And I don't know exactly how many death penalty trials I've done, but a high number. And I think maybe 30, maybe 40, somewhere in there. And I have 0 people on death row. I had one.
Which is an amazing record. Yeah.
Thank you. Yeah, I'm pretty proud of that fact. I mean, you got to take the wins where you get them. And these people are not on the street, but I have been successful in avoiding the imposition of capital punishment. For every client, ironically, save and except one, who then, after the conviction, shortly after the conviction, had his sentence reversed. So I have an asterisk, I suppose. But I have 0 people on death row, and having been doing this for as long as I have, and having been representing the murder cases, those accused of homicide that I have, to have that sort of record is something I am pretty proud of, because I personally just don't believe in the death penalty, which is fine. Some do, some don't. Some people in my family believe in it, which is fine.
Right. And we know of one particular case where the gentleman was ultimately proved, or not proved innocent, but let free or let go because the evidence wasn't what they presented originally.
Correct.
So that there's always that potential that somebody, you don't want to see an innocent person. Not that they're going to walk free either, because as you mentioned, even though they're not on death row, they're still incarcerated.
They're still incarcerated. They're still in the system. And so, people don't realize certain things too. The cost to give someone the death penalty is 8 to 10 times more than the cost of life in prison, which at first blush doesn't seem to make any sense. But you need to realize if you have a death penalty case, there's automatically 2 lawyers appointed at every level of the proceedings instead of 1. If you have a death penalty case and the person gets the death penalty, you have an automatic right to appeal all the way to the United States Supreme Court. So you start in your local district court level in Nevada, then you go to the Court of Appeals, the Nevada Supreme Court, the magistrate here in federal court, then the Ninth Circuit Court of Appeals, then all the way to the United States Supreme Court. If you don't have the death penalty, you stop at the Nevada Supreme Court, period, end of story, and you're done. And the amount spent to keep that death penalty in play through what could be decades worth of appeals is inordinate. Plus, you have special housing considerations that cost more money as opposed to general inmate population when someone gets life without parole or life with parole that are also exponentially more expensive.
Right, and those, like as you mentioned, they go on often for decades, many years of appeals and motions and all sorts of things, right?
Compared to someone in a non-capital homicide case, their whole matter is going to be done probably in 3 years, and that'll be that. And there's going to be 1 lawyer working on that case, not 2, plus an investigator. The team involved in the capital litigation is huge compared to the team involved in a normal, if that's the right word, a normal homicide case. And people don't often realize the cost, which ultimately falls to us as taxpayers to do that. So now you take Nevada, where you have this exorbitant cost, coupled with we haven't executed anyone here in a long time because of infirmities with the death chamber or the cocktail administered or a host of other reasons. One must wonder whether or not the economic impact of that which what we're doing in our own state is worth it.
Right. Yeah, and I guess every state has struggled with that, and obviously you have people that are opposed to the death penalty as well. So that's an ongoing issue that's probably not soon to be resolved. That's some great information, Tony. Like I think it's important for part of what our mission, what we're doing here, is educating people, because many people they think they know what the law is, but it's great to hear that from you, somebody who lives it, who's in the courtroom every day and dealing with that, where we get accurate information, not TikTok and social media information, which we all see on a daily basis.
For sure. No, and I think it's important, and I think like even in our own country. Where at one time there were so few states that had the imposition or the no death penalty. I misspoke. Now we're at 30 to 20. So the tide has definitely shifted in favor of when there's a homicide case, life without parole is the most egregious penalty. And we talk about that in the death cases we do with the jury. Had this crime occurred in Colorado, no matter how horrible the crime is, that person's never getting the death penalty, right? In Nevada, they're exposed to it, but we got to keep it reserved for the worst of the worst, right? And everyone that gets tagged with the risk of the imposition of capital punishment, there just can't be that many people that all qualify as the worst of the worst.
Right, and as you mentioned too, cruel and unusual punishment comes into play. There's obviously politics comes into play with all that too. It's hard to avoid that, really.
Well, for me, it's pretty simple analysis. The death penalty is the perfect punishment, right? Because once it's done, you're done. But human beings that are imperfect are the ones given the responsibility of the imposition of a punishment we can't come back from. You mentioned earlier a case that I had where someone's actually innocent of the crime that they were accused of. That gentleman spent 25, 30 years in custody for a crime he didn't commit. Had he received the imposition of capital punishment, he'd be dead.
Which could have happened.
Which could happen, that's right. And now what do we do? Well, the evidence now shows that he was not responsible for the crime with which he was accused. Well, now he's dead. And so now what do you do? Right. And so to me, it's a very simple analysis. It is our own imperfection as human beings that causes the potential for that imperfection to be baked into what is the ultimate and most final of all punishments. And that to me just doesn't sit well. And while I can, speak of statistics or what I've been able to do, what I've been able to avoid relative to capital punishment, not all my colleagues have that same story. And in the death penalty, unfortunately, the quality of the lawyer makes a difference, which to me is horrible. The quality of the lawyer should not make a difference in something so final, but it does. And I have had the misfortune of seeing colleagues of mine really phone it in. And now when you're phoning it in and it's a death penalty case, you're adding even another wrinkle of imperfection, which is lack of desire, lack of drive, whatever it is, on the part of the defense attorney. So if you look at lawyers here, even in Las Vegas, if you see a high degree of repetition of lawyers that represent those accused of capital offenses, and you see that they have a lot of people on death row, you got to sort of raise an eyebrow and say, could that be because they phoned it in?
Right, or competence.
And maybe they didn't. Maybe they just drew the short straw every single time.
Right.
But I'm not so sure I subscribe to that school of thought.
Yeah, and that's a good argument and a good case to be made because against capital punishment, because there's so many parts and pieces to that puzzle, and people think it's always cut and clear, he did it, but it's way more complicated than that. And who represented them, and the jury, and then like kind of everything that you talked about. Tony, tell people how they can find you and find the podcast and all that.
Sure. You can find us on Apple Podcast, and you can contact us at sgroandroger.com.
Awesome. And if you have questions that you would like us to cover or topics, please feel free to contact us. Our email is in the podcast description. And we are also on iHeartRadio. We're on Spotify Podcasts, Amazon Music. It's growing. This is our second episode. And I should say, too, we're coming to you live from the office. So if you hear a conversation in the background, that's why. But thank you so much for joining us. And we really appreciate it. Please like and subscribe as well.
Thanks for having me. I appreciate it. We'll see you next time.